Hello, hello, and good evening to all to this edition of interview preparation discussion. I'm your host Pradeep Verma. On this edition of our discussion, we are going to discuss about the office of the governor and the related controversies about the office of the governor. We have observed since the inception of the constitution and the inception of the office of governor that the office of governor has always been in controversy, be it for the using its discretionary power for imposing president rule under article 356 or appointing chief minister in the circumstances of hung assembly, or the recent one under article 200, which give governor the power of assenting or withholding bills. So through all these issues, the office of governor has become an office of controversy. So to discuss on this further, we have with us distinguished panel of guests. We have with us Mr. Pawan Kumar Sukla, Senior Advocate, Allahabad High Court, and we have with us Ms. Komal Kumar Gupta, constitutional expert and also legal expert. So to begin with, I would like to know from Mr. Pawan Kumar that what is the constitutional provisions related to the governor and why there is a need of the office of governor in first place.
Okay, thank you, Pradeep. As you have made me the senior advocate in the Allahabad High Court, so I would like to introduce the certain constitutional provision. But before going into the constitutional provision, we should know that the office of governor is not something new. It was already existed during the British rule, and when the constitutional framers were framing our constitution, they had adopted certain constitutional practices all across the globe that was going on there. So one of the practice was the office of governor that was being taken from the Canadian Constitution. So uh, first of all, coming to the constitutional provision, the office of governor has been defined in the part 6 of the Constitution, and in part 5 the office of president has been defined. But when we see that office of president and office of governor, the difference between them, our constitution does provide certain discretion to both of the post. Like when it comes to president, the discretion that has been provided to the president is just situational discretion and not the constitutional discretion. For example, in case of any party not getting complete say majority in the Lok Sabha election or the hung election or the hung parliament case, in that case the president will have the discretion to appoint the prime minister. But uh, along with this type of situational discretion, there are certain constitutional discretion that has also been provided to the office of the governor. For one of the example is under article 200, as you have mentioned, that reserving bills for the reconsideration of the president, that has been one of the constitutional discretion, and also writing report to the president of India for establishing or say proclaiming the president's rule in any state. So these are some constitutional discretion has been provided. And coming to the your question, that what is the need of the office of governor. So since India is a parliamentary democracy and we have copied such parliamentary democracy from the UK, and UK had provisions of having a nominal head in the form of their monarch. But in India, what we have done, that at the center level we have given that nominal head power to the president, and at the state level we have given that nominal head power to the governor. But also governor acts as a acts as an agent of center. It was very necessary because when India got independence, there were certain secessionist forces acting in the country. So it was very important for the center to check to put a check on the functioning of the state government. But as you have mentioned about the Article 200, we will come to Article 200 and the granting of assent to the bills in the upcoming discussion. So yeah, over to you.
Okay, thank you, Pawan. You explained the related constitutional provisions very well. So coming to Komalji, as we discussed, the Article 200 and this recent controversy is all about granting assent to bills, withholding assent to bill, and governors were using discretionary power. The governors were using this power as their discretion. But in the recent judgment, the Supreme Court has held that governors do not have any kind of discretion in these matters. If they are withholding bill, they need to send the bill to the state legislature as soon as possible, so that if legislature pass that bill again and resend to the governor, then governor is bound to give assent to that bill. So I would like to know from you what this recent controversy is all about, though I have thrown some light over it, but I would like to know further from you what is this controversy is all about, and what is the decision of the Supreme Court over it.
Um, Thank you, sorry, Pradeep, for this question. As you mentioned, the recent Supreme Court judgment, this judgment came into the light of ongoing controversy of Tamil Nadu governor, who has withhold some bill that has been passed by the state legislature of Tamil Nadu. So the question that is it right, wrong on the Supreme Court judgment? See, we need to understand that when Constitution framers gave this power to governor, it was with a very pure intention, so that it may that anything which goes against public interest, which endangered high court position, or anything which is against Constitution, that kind of thing, governor has power to withhold that bill with themselves. But in recent cases, earlier also, we have seen that misused, and the governors are alleged of misusing this power. And same happened in Tamil Nadu, and as per that, Supreme Court judgment came. And after that judgment, Supreme Governor of Tamil Nadu, I don't remember the name of the bill. I think it was health related or something. The Governor of Tamil Nadu passed that bill and sent other bill to President. So the question that whether Governor can do this or not, can Governor withheld uh, can keep such bills which is passed by a democratic government, elected government of the state legislature with unlimited time? That is the main question. And as per
Right.
my understanding, a unlimited, an undefinite time should not be there, because somewhere it undermines the state legislature power, which is a accountable democratic government over there. What should be done, as the Supreme Court also said, that there should be a timeline within that governor has to pass the bill or reject the bill. There cannot be a absolute, pocket veto over that. So that's all from my side. Thank you.
Okay, rightly said. And in recent judgments, Supreme Court has also clarified that in the first place, governors will have to take stand over the bill as soon as possible, whether they are assenting or withholding it. And if they are taking decision that they are withholding the bill, withholding does not mean that the bill ends there. The constitution provided that after withholding the bill, governor needs to resend the state legislature the bills with the message to reconsider it. And then if state legislature repasses it, then governor is bound to give his assent.
Yeah,
Okay,
you correctly
so
said it. It was amended later in our constitution, and I think there shouldn't be any absolute power to governor, because
yes, and
the
this has been
governor
clarified
has
by
been
Supreme
given,
Court.
yeah,
This has been clarified in the recent judgments by the Supreme Court that governors do not have absolute veto. They are bound by the decision of the state legislature. So that
this
matter has
power
been
shouldn't
solved.
be politicized. It is
Yes,
there for the betterment of the country, for the betterment of the people. It should not be used for any person or any governor, any political party shouldn't use it for the benefit of their own. So that's all from my side. Thank you.
Right, right. So moving to the next stage of our discussion, I would like to move to Pawan. So Pavan, the various bills that has been upheld or kept on pending by the governors of the state, be it Tamil Nadu, Kerala, or the Punjab. So most of the bills were related to the appointment of the vice chancellor, and as we know, governor is the ex officio chancellor of the universities of the state government. So in that capacity, governor have the power of appointing vice chancellor of state universities. But again, governors misuse this power and use that power arbitrarily. So various state governments are taking back this power from governor to appoint vice chancellors. So I would like to know from you that is this power of appointing vice chancellor by the governors should be taken from governors, or governor should limited to the constitutional duties.
Yeah, you have rightly pointed out this issue of appointing or appointment of the vice chancellor of the universities. So by default, it is a apprehension or a tradition in the India that governor is the by default chancellor of the state university. So before addressing this question, we need to know the role of the governor. Why the governor was used to appoint? As I had mentioned earlier, also that governor was the agent of center in the state. And when India got independence, there were many secessionist forces that were operating in India, and many part of India were not giving their assent to join the India. With a long struggle under the able guidance of our Iron Man Sardar Patel and VP Menon, the India got united under one umbrella and one flag. Uh, but coming to your question that yes, state universities, the state government should have control over the state universities. At the same time, state government should not have any discretionary powers to appoint anyone, as we have seen that at the local level, especially the nepotism that follows at the local level is very high in India. But when it coming to the central stage, the nepotism is there, but not at that level, which is being seen at the local level or at the state level. So completely completely waiving off the governor from the role of the chancellor or the appointment of the vice chancellor, I think it should not be done, and the governor should have should involve with the consensus between the two parties, like the state government should representative state government should also be there, and the representative from the center, that is the governor, should also be there in the appointment of vice chancellor. And coming to your the first question that you had asked, that why governors can sit on the bill for indefinite time or not, as the article 200 states that governor cannot sit on the bill for the indefinite time, and they had to either give the assent or reconsider the or keep the bill for the reconsideration of the president, or return the bill for the consideration of the legislative assembly. And when the legislative assembly give back the same bill, they have to give their assent and they cannot withhold it. So and the article itself 200 itself read the may as soon as possible the governor should return the bill. So Supreme Court had also clarified this in the famous Nabam Rabia case in the of 2016, clarified that governor cannot have the discretionary power to sit over the bills for a longer time, as sitting on a bill for indefinite period may paralyze the state government, the function of the state government that has been democratically elected by the people of that state. So, so the many states now came in the controversy, like Tamil Nadu, Kerala, Telangana, and Punjab. And regarding the appointment of vice chancellor, West Bengal government also came in news. So there was another clause that was that I need to mention here, that regarding the proclamation of president rule. So that was also one of the discretionary power, not discretionary power, that governor used to write the letter to the president to for the proclamation of the president rule in the state. So in the famous case of SR Bomai in 1994, Supreme Court has also given certain guidelines, following which the proclamation of state emergency, or say president rule, should be done. So I think the role of governor shall be constructive in nature instead of withholding the bills and doing deconstructive work. And the state government and the central government should function in the collaboration to for the better serving service of the people. Thank you.
Okay, okay. So, as you mentioned that the office of the governor was created in the circumstances in which India was facing various secessionist tendencies. So, at that point of time, a agent of the center was needed at the state level, which can inform the central government about the activities which are taking place in the state. So, accordingly, Constitution has made the provision under Article 155 that the governor will be appointed by the president. So, in that case, governor act as the agent of this center. So, moving to Komalji, and in one of the judgment, Supreme Court of India has clearly said that the office of governor of a state is not an employment under the central government, it is an independent constitutional office. But what we are observing, what we are witnessing in practical terms, especially in the opposition ruled states, governors are literally acting as the employee of the central government, means whatever uh, command is coming from the central government, they are acting uh, through that command or obstructing the activities, especially in the opposition ruled states. So, what's your view on this?
Uh, See, yes, it's true that right now we are witnessing such cases where government is alleged of playing a agent of center and a political agent of center. But we cannot generalize this to everyone, and to those we need to have keep intact the dignity of the uh, office of the governor. We might have encountered some incidences, but to generalize to everyone, it would not be a correct thing. And like that's why there is a provision that governor will act under the pleasure of president. So we have seen that the we can say the freedom of governor of acting with his discretion is sometimes rare, like because if they are not acting according to the central government, so they might get replaced to somebody else, and we have seen such cases. And I would like to, that is all from my side on this question. And the question that you asked, Pawan, that whether vice chancellor, appointment of chancellor, this power should be taken from governor or not. I would like to give my opinion on this, that it shouldn't be done, because see, this, if we give it to the central sorry state government, there is highly chances that this position will get politicized. And that
Right,
is why, it has not been had been given to say, from the beginning, to the state government. And officer to office, all these things that can be happen. So in my view, we shouldn't give this power to back to the state legislature. In a state, what should be done? There should be a coordination between the state government and governor, a smooth coordination to run the governance of that state properly. Thank you so much.
okay,
One
okay.
question I would like to ask you from Pradeep. As a Sarkaria, various center-state relation commission has been formed in the India, like Sarkaria Commission, Punchi Commission, or Raj Mannar Commission. So every commission, by time and again, had given certain recommendation that governor should be appointed with the consultation of chief minister also. That means there should be a consultation of the state government and the representation of state government also. It should not be done unilaterally by the central government. And the way president is being impeached by the central government on the charges of violation of constitution. The state government or the state legislature should have also this power to impeach the governor in case the governor is failing to comply with the rules of the legislature or the rules of the constitution. So, what do you think that is there a possibility in India that a governor should be appointed like this, and they will have complete discretion in their own field, and not act as a mere agent of the central government, but act as a independent constitutional post, as you have mentioned earlier?
So, thank you for this question. We need to understand first that why governors are compelled to act in a partisan manner. Because we need to understand the constitutional situation of the governor. Though the constitution has mentioned 5 years term for the governor, but in reality, uh, the tenure of the governor is not secured. The governor held the office during the pleasure of the president, means president can remove the governor at any time. So there is always insecurity in the appointee of the governor. So, in that case, since they are being appointed by the central government and there is no insecurity, so they also feel the pressure of the central government and they bound to act according to the wishes of the central government. And coming to the next, that various commission has recommended that there should be consultation with the chief minister in the appointment of the governor. So these recommendation are, I think, right. And because at the end of the day, it comes to the democratic functioning of the government, because the government which is headed by the chief minister is elected by the people of the state. So whatever legislation they are enacting in the state legislature, there should not be any kind of obstruction, because it is a kind of uh, 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 it is a kind of failure of the wishes of the people. So definitely a mechanism should be there where the chief minister of the state should be consulted while appointing the governor of the state. So when there will be consultation and the appointee to the office of the governor will be appointed after consultation of the chief minister, so there will be smooth functioning of the government. And one more thing that I would like to add is that uh, our constitution has mentioned only two qualifications for the office of the governor. One is the citizen of India, and another one is he should be completing 35 years of age. But there are some qualifications which are based on convention, but there should be some qualifications, like he should not be he should not have immediate career in politics. He should he should be distinguished personality who has knowledge of constitution. So there are some more qualification that needs to be added, which are recommended by various commissions. So this qualifications part and this issue of discussing with the chief minister, if these things are implemented, then this controversy can be reduced to a certain extent.
Pradeep, I would like to ask you what is your opinion on this governor and vice chancellor appointment of vice chancellor issue? What is your take on it?
See, as you also mentioned that when it comes, because chancellor's post and vice chancellor's post are important when it comes to higher education, and any educational institution should be functioning according to the constitutional provisions, not according to the wishes of the political masters, so that they can influence the educational institutions or the office bearer of those institutions according to whims and fancies. So I think the provision that has been made by the constitutional experts, it would have been some insight, and they have made this provision with clear understanding. And I also believe, though I am not completely clear about this issue of appointment of vice chancellors by the governor, or should they be appointed by the state government, but I think uh, political interference should not be there in the state universities. So if governor is appointing the vice chancellor in a without any partition, without any bias, then I think there should not be any issue that vice chancellor being the means the governor being the chancellor appointing vice chancellor. There should not be any issue. And if governor is also appointing the vice chancellor as an part, in a partition manner, so it would not, it is not good either being appointed by the governor or by the state government, because at the end of the day, it will become the political appointees. So there shouldn't be any political interference, especially in the higher education institutions.
Okay.
So I think we should end this discussion with one of our concluding remarks. So one last question that from I would like to know from Pawan, that various commission like Rajmannar committees, they have demanded this extreme steps that we should scrape the office of governor altogether, so that this controversy can be solved completely. So what's your view on this?
See, in my opinion, what we have seen in the recent time that there are certain secessionist forces still exist in the country, and moreover, the state government is with the especially with the rise of regionalism that we have seen. I think the role of governor is very important in making the India as a unity, and to protect the unity of the country. And the various commission have recommended, although to scrap the office of governor, but they have also recommended that governor should be appointed with with the consensus approach, following the inclusion of the state government role also. So state government should have a say in appointment of the governor, and also the same way the president is being impeached, the governor should also being impeached for the violation of the constitution by the state legislature also. So state legislature should have a say in that, in the case when the central government is completely dominant, where through the governor, state government should have a say, and India should be should be rightly called as the federal country, as it has been mentioned by the Supreme Court judgment, and federalism has been declared as one of the basic structure of the constitution. So scrapping the office of governor should not be there, and consensus based approach should be there.
Okay. So last concluding remarks from you, Kamalji.
I will say that office of governor shouldn't be skipped at all. It is very necessary for the unity and integrity of India. However, we need to agree that we need a structural reform in this office. As Pawan mentioned, impeachment of governor. A governor shouldn't be only be pleasure of president, or indirectly on the pleasure of central government. So that is my take. Yeah, thank you.
Okay. So what we are, concluding, what we are summarizing, in summary, we can say that the office of governor is important to maintain the unity and the integrity of the country, being the agent of the central government. But we need certain structural reforms in the office of governor, be it in terms of providing security of tenure, or providing clear cut qualification for the office of governor, and limiting the discretion to the office of the governor, whatever the constitution has provided. So these are the things that needs to be considered to reform the office of the governor. So this is how this controversy can be tamed. So thank you
And
everyone
one more
for.
thing that, one more thing that the person who is sitting on that office, that is very important. That's why being ethical is very important, because
Right.
things are, laws are made, things are given. A unethical person will always try to find a loophole. An
Okay,
ethical
and I
person
would
will
like
always
to
try to protect it.
add the comment made by the Supreme Court in that context. In this context, that Supreme Court has said that the office bearer of the office of governor, they need to do soul searching. So it is related to that, that they need to be ethical. They need to think that they are holding the highest constitutional office in the state, so they should act accordingly. Okay.
Yeah.
So
Okay.
one of the committees had also recommended that the anyone who is bearing the office of the governor should be retired from the active politics. So this can also be done.
Right. So I think we should end today's discussion. Thank you everyone for participating. We will meet in the next discussion. Thank you.